when thinking about how to do something better, it's always helpful to understand the options and examples of how, in this case, other states redraw their districts. Is a good place to look for reform options. Not that we couldn't do something entirely new, but you know, this is a complicated process, and new things are fraught. And if we look to the other states, those processes have been sort of vetted. There are two basic categories of redistricting institutions. One of them is the mechanisms by which the maps are drawn, and these are usually what's discussed when talking about redistricting reform, but also the criteria by which map drawers assess their potential maps are also set in policy sometimes, and they vary considerably from state to state. So I'm going to talk about them. And in fact, I'm going to talk about the redistricting criteria first. But when I say criteria, I mean the standards by which an offered set of maps is judged. And these can be informal, traditional, self-serving. You know, for example, a lawmaker might judge a map based on whether he is more likely to get reelected under it, or a party official might judge it based on what she expects the expected partisan outcomes to be. But there are also policy-based formal criteria that must be taken into account when drawing maps if they're established in policy. And these can be changed, of course, by policymakers as they so desire. Now, first of all, the U.S. Supreme Court, since the 1960s, has weighed in on the issue of redistricting, and they've laid out three criteria that all states and local policymakers must follow. Equal population, basically, again, that the districts are substantially equal in population. There's different tolerance for inequality at different levels, but you know, basically what we're talking about here are districts need to be equal in population. Contiguity, that is, districts, all the land mass of the districts have to be touching one another, you know, unless you have an island in your district. And race is another question of criteria that the redistricting, that the Supreme Court has weighed in on. First of all, maps cannot purposely disadvantage a racial minority. That's pretty clear. But the court has also held that race can't be the overriding criterion for maps. There's a fair amount of ambiguity over time here, and conflict, sort of Full Employment Act for lawyers, I think, on the issue of race and redistricting. Not to mention political scientists who do redistricting consulting. But you know, and perhaps surprisingly for some, the Supreme Court has said that political advantage is a criterion. Is okay to take into account as long as it doesn't violate some of these other ones. So they have not said that you can't look at political outcomes. Okay, now the states, you know, there's a level of government with the constitutional responsibility for elections in most election law, and they have established a variety of criteria in policy to whether map is good in some sense. And there are 6 of them that are sort of the traditional or main ones, or that have the most usage among the states. So I'll just walk through these. First of all, 44 states have established in public policy and statute a rule that local boundaries must be followed to the extent possible. County boundaries, municipal boundaries. The idea here is that legislative boundaries that match other political boundaries with which voters are already familiar will enhance accountability and voter awareness and understanding in the legislative elections and so forth. Compactness is another one. 36 states say that the districts ought to be compact. The establishment of this criterion speaks directly to the complaint that gerrymandered legislative districts tend to be spindly, sort of oddly shaped pieces of land. It's sort of a face validity thing. If the districts are compact, they look less like somebody is trying to pull a fast one, I guess. Section 2 of the Voting Rights Act of 1965. VRA is a federal law that prohibits racial discrimination in voting procedures, including redistricting. 27 states have seen fit to require that their congressional legislative districts meet VRA standards, even though, because it's federal law, all states have to do it. But 27 states have codified this themselves. Communities of interest and the preservation of communities of interest as a criterion is a relatively new legal concept and criterion in legislative redistricting. One definition of definition of communities of interest is, quote, when residents share substantial cultural, economic, political, and social ties, close quote. And the idea here is that preserving communities of interest in a legislative district can enhance representation by making political interests and the policy interests of legislators' constituents more homogeneous. 13 states suggest or hold that the preservation of the previous district's core is desirable, so the idea here is when new districts are as similar as possible to the old ones, both incumbent lawmakers and voters know each other better, which allows for better informed citizens, better representation, more accountability. On the other hand, 12 states prohibit the protection of incumbents as a consideration in the map, so that shouldn't be an issue in these 12 states. Basically, they establish this criterion in recognition of the basic conflict of interest for legislators when they have a hand in drawing their own districts. Obviously, this one has probably a pretty direct impact, conflict with the previous one, and it's certainly the case that there's lots of overlap and conflict among these various criteria, and so getting them a particular set of maps to match all these criteria, if they're so established in policy, is not an easy task. Now, there has been some study of the impacts of these criteria. For example, there was a couple of U of I grads actually did a study recently on of all the impacts of these criteria on race, racial minority representation, and they found that only compactness as a criteria has an impact here. And another study showed, for example, that the more of these that a state has on the books, whether they're whichever they are, the more of them there are, that increases competition, probably because it makes political gerrymandering more difficult. And having them codified and followed also can sometimes decrease litigation because it provides a rationale for map choices that are made. Okay, now on to redistricting mechanisms. Mechanisms here, I'm talking about the actual policymaking process that the states use to propose and approve their maps. And there's two major categories and 6 subcategories. The major categories are the legislative process, and some 37 states use the legislative process to set their maps out, and 13 states use commissions of some sort. Really, for the most part, I'll go through these, but I'll say at the end that there's less difference here than really meets the eye in terms of the impacts. Now, among the 37 states that use their legislative process, 20 of them use the straight-up normal legislative process. The maps go through like a regular bill. The governor has to approve, or maybe override the veto, or whatever. Another 2 states use the normal legislative process, except they cut the governor out. And so this probably even exacerbates the conflict of interest problem, because if legislators are drawing their own maps and the governor doesn't even have a hand in it, that's possibly a fox guard in the hen house sort of thing, at least some would argue. Now 11 states, including Illinois comes in here, use a backup commission. That is, if the legislature fails to decide on a map and the process doesn't work for whatever reason, what would happen in the next election? Election is coming, you can't compel the legislature to act, you need districts, and the Supreme Court says you can't use the old districts, so what will be, these 11 states, they have a backup commission, which will then, at some date when the legislature hasn't acted, they will take over and draw the maps. And as a side note, the 22 states above here, and in fact, actually, the 26 states, other than these 11, they also have a default backup mechanism, but in their case, it's the courts, and it's not codified, but that's just what happens. The courts take over if the legislature can't get it done. Finally, in the legislative process, you have 4 states that have an advisory commission set up in advance of the legislature taking a look at this. And the idea, whether the advice is taken varies considerably. Iowa falls into this category. It is very much a staff-driven process. Iowa is often held up as sort of by reformers as a sort of golden ideal of redistricting in the country because the staff do it. They're not allowed to take into account political or incumbent locations. And the legislature basically rubber stamps more or less what the staff do in the end. On the other hand, it's not the mechanism per se that does the job, because New York, Pennsylvania, and Maryland also have this Advanced Advisory Commission, and they're not, to my knowledge, ever held up as the ideal of redistricting reform. Now, the 13 other states have commissions of some sort. The first kind is a partisan or bipartisan commission in 11 states. Members are selected for these in various ways. If what you want to do is purge political influence from the redistricting process, these bipartisan partisan commissions are largely toothless, as I mentioned in a minute. The thing that's really different here are these independent commissions, and there's only 2 states that do this, and they're both very new. Basically, with the independent commissions, you get a process established that purges, or tries to purge in some sense, the political and office holder influence on the process. This starts in Arizona adopts this reform in the 90s and uses it for the first time in 2001. California did it a decade later, and so Arizona's done it twice under this process, and California once. The Illinois initiative that just failed was more or less based on the California and Arizona experience of an independent commission. Now, the impacts of these mechanisms are pretty straightforward. The ones that work on the legislative process, no matter how they do it, if you get unified government, you're going to get partisan gerrymander. If you have divided government, you're going to get an incumbent protection gerrymander. And this varies in degree, but it's pretty strong, and there are pretty strong and consistent patterns here, unsurprisingly. The real exception here is Iowa, and that's just because they're Iowa. Now, in terms of the commissions, the bipartisan and partisan commissions, you get the same result as in the legislative process. If it's bipartisan, it's going to be an incumbent protection gerrymander. If it's partisan, it's going to be a partisan gerrymander. The independent commissions, Arizona and California, again, the unique ones, it's too early really to tell with certainty what's going to happen with these things, but they look promising. And for example, in California, after the 2001 redistricting, which was a partisan gerrymander for the Democrats, throughout the decade of the 2000s, 99% of incumbents who ran were reelected, and there were 0 party changes across legislative districts, and that includes Congress, and that's a lot of districts in California. On the other hand, in 2012, under this new system, already the new maps put various incumbents in districts together and looked like some more competition. The Republicans still cried foul that this was a partisan gerrymander, but it sure was a lot less so than the previous one.